Our next case is number 19-175. This is a partially impounded case, so I assume that has to do with names and maybe some financial information. I'll trust the lawyers not to mention whatever they should mention. It is MICHELON versus DESCHLER. And we will hear first, I believe, from Ms. Coyles. Is that right? No, I'm going first. Oh, I see. Okay, I'm sorry. I messed that up.
We're not aware of any impoundments in the case, Your Honor.
Well, I'm guessing the names of the children and the financial information.
Were there financials?
Oh, yes, the financials.
Okay.
Good afternoon. May it please the Court, my name is Maureen McBrien. I represent Melissa Michelon, the appellant here, and the plaintiff below. I was also trial counsel in this divorce trial in 2017, approximately 2 years ago. The issues on appeal relate to the Judge McSweeney's custody determinations over the parties' 3 children, Ricky, Cecilia, and Zachary, who were 7, 5, and 3 at the time of the trial. In particular, we're seeking that the award of joint legal custody and equal parenting time, the 50-50 equal parenting time for mother and father, and the mandate that the children attend the Sudbury Public Schools be vacated and the matter remanded to a new judge.
Can I ask you a question about, I'm unclear on this. So there were temporary orders, and as I understood it, under the temporary orders, the mother did not get any time on weekends. Is that correct?
She did get a Friday night, every alternating Friday night.
Okay, so if you were going to just tell me in terms of days, like days of a week or days over a 2-week period, how much time did the mother get under the arrangement before the judgment?
Okay. So the arrangement before the judgment was premised on my client who was going through a residency, so it was a little bit odd. It was that father would have the children in week 1, Tuesday to Thursday, and in week 2, Wednesday to Thursday, and then he would have alternating Friday to Sunday and alternating Saturday to Sunday. And mother had the rest of the time, so that equated to father having 6 out of every 14 overnights and mother having 8 out of every 14 overnights. 4 transitions for the children in week 1 and 5 transitions for the children in week 2, who were then ages 1, 3, and 5 when the order entered.
Okay.
It continued for a period of over 2.5 years by the time the judgment entered, despite the fact that my client's schedule had normalized, her residency concluded, and she had a normal work schedule working.
All right. I'm just, if you don't mind. So, and then after, in the judgment, her time remained 8 out of 14?
No, after the judgment, it was 7-7, 50-50 equal parenting time with the children with father Monday and Tuesday overnights, with mother Wednesday and Thursday overnights, and the parties alternating the weekends.
Okay, but one beneficial result of the judgment was that the mother got weekends. Yes. With the children, which she did not have before.
Yes.
Right? And so when we're looking at this as an abuse of discretion, we had a situation beforehand where it was not exactly 50-50 in terms of the amount of time, but the mother had no weekends. And afterwards, it's 50-50, but the mother gets weekends. Both parents work.
Yes.
So can you explain to me how, because we don't look at this, I don't believe, as though what existed before did not exist. We don't look at it in a vacuum. So I think that perhaps the question is, was it an abuse of discretion to change the parenting time in this way, considering what it had been before?
Okay, so
now, you're not claiming that it was a mistake to give her time on the weekends.
No, both parties advocated.
Could the judge
for that?
And would it have been an abuse of discretion for the judge to leave the parenting time exactly as it was before the judgment?
Well, I think both parties, the one thing they did agree on was that each party should have alternating weekends.
Why was that?
Because of the fact that my client's schedule had normalized and she had been without a weekend and that there were too many transitions. They both agreed on that. So it was no surprise that the judge resulted in a schedule, the judgment resulted in a schedule that afforded the parties something that they both wanted, which was alternating full weekends. Where the judge erred and abused his discretion is that under these facts, many of which he ignored, there was no support in the record for expanding the father's parenting time.
Okay, so let's slow down a little bit there. You're saying that as a matter of law, this judge could not change the 6-8 schedule to 7-7?
No, I'm not saying that. I'm saying that it was an abuse of discretion to award parties 7-7, 50-50 shared parenting when the facts do not support them being able to, that schedule being in the children's best interest, or that type of parenting arrangement, where there was numerous facts that bear on the father's parenting abilities and judgment that were entirely ignored.
But so this is what, I get the point about the facts found, to the extent they were found. I mean, the judge at least crossed out some paragraphs of this adopted thing, but I agree that the facts found don't address some of the issues that the evidence raises. Questions about the ATV accident, questions about the DUI. In a minute I'm going to ask you about the questions about possible corporal punishment, or I can't quite tell what was going on. But if mother was willing to have father have the child 6 days a week, how can it be an abuse of discretion to increase it by 1 day?
To be clear, the 6 days a week did not arise by agreement of the parties. It arose after a temporary order hearing, an argument between the parties.
And what was mother's position at that hearing about what should happen?
I was not present at that hearing. However, my understanding is that the children would be primarily with her, and that there would be a parenting plan for father that would have the children would be with him less than her. She would remain, her residence would remain their primary residence. In fact,
well, 8 to 6, it is her primary residence. I'm trying to figure out. I mean, the problem I have, I guess I'll get to the corporal punishment piece of this, because to me that seems like the most critical piece of this. The mother seems to be making allegations that something goes on at that household that is unhealthy for the children in terms of violence. There's at least some evidence or claimed evidence that something looked like a hand mark,
yes,
something like that. You have not, though, she has not, though, said all visits should be supervised or there should be no visits. She says a certain number of days, and the judge picks a different number of days. And I'm trying to figure out how you can understand why a judge might be loath to credit allegations like that if the mother's position is not violence is taking place and the children should not be alone with this man, which is a position obviously we see sometimes. That is not mother's position. And once that's not her position, with a presumption of 50-50 custody, which seems appropriate in an ordinary case, how can we say it's an abuse of discretion?
So, first, there is no presumption of 50-50 custody, and the Giannis case, I think, states that.
What is the presumption?
It's a fact, case-by-case analysis, looking at the history of the parenting responsibilities of the parties, and what's in the children's best interest. And I think rather than viewing this case from 50-50 is appropriate unless you show something to prove it's not, I think that flips the standard on its head. There was an established precedent here of the kids flip-flopping back and forth.
Okay, so 6 and 8 is
their best interests, and there was constant conflict. There was allegations concerning incidents. My client, the judge, heard about it and was concerned about DCF involvement. And
asked about DCF involvement and was told DCF had been involved and wasn't anymore.
Correct. And my client did sound the alarm on numerous occasions, was unable to essentially get any traction in movement on the schedule by agreement of the parties. She was unable to effectuate a reduction in his time, although she went to court over his pornography use and his time was suspended during the proceedings. She did bring the matters to the children's physician's attention, to the lawyer's attention. The record shows that she was concerned about his parental judgment, about his alcohol
use. We understand all of that.
Right. So
the one thing that we don't do, though, is retry the case. Right? So we have to look at this all as within the lens of the standard of review, which is abuse of discretion. I'm going to add to the mix here, as I understand the record, that there was a partial stipulation for judgment that dealt with holidays, additional parenting time, vacation, parenting time issues, very detailed, that the parties reached, telephone contact, Skyping, all of these things, educational expenses, all of these things the judge could also consider, correct, in fashioning the final judgment. The parties agreed to all of those.
Yes, with the judge's input and influence to try to resolve the case.
Okay, but that's not improper.
No.
Okay, so and it looks at least that the parties could cooperate to that degree. It looks like the mother was willing to have a vacation schedule.
The mother has always been the parent, willing to foster a relationship with the other parent despite concerns, provided that she's in the driver's seat with respect to matters pertaining to the children's education, and that she's able to participate in their medical care and have the children more than him, as had been consistent with what her role was when the children were very young. And that is a factor that the courts must consider under the case law. Which parent here is able to foster a relationship with the other parent? That wasn't father here. That was mother. Mother was the one who was offering father time when his father was in town, as opposed to father who was making mother barter for Mother's Day, for Easter, for time when her father was here. The judge found him to be rigid. Where are all those findings about the father's rigidity that the judge made contemporaneously on the record as he heard the evidence? He's concerned about animal abuse. He's concerned about child abuse. He's concerned about alcohol use. He's concerned about father's rigidity. Where is all that in the findings? You can't just render, 50-50 custody, joint legal, and by the way, the children go to school in Sudbury, father's town, without any reference in the record to all of these very concerning, and I agree, very concerning observations that the judge makes contemporaneously while listening to the testimony. How do you reconcile that? All of those very concerning aspects of this case with the judgment reached. You can't. And that is why this case needs to be remanded. So we don't
usually find, judges make comments from the bench and they're not necessarily findings. Well, I guess you just determine what happens. I mean, you're just asking that there be a remand for the judge to make findings. The judge makes those findings. They may or may not be beneficial to your client.
Well, I think he has to. There's a case that's adoption of Abbey. Troublesome facts are to be faced rather than ignored. I want the case remanded. I want the facts about the father's lack of parental judgment, that ATV example, the alcohol use, the pornography, and I want those all to be addressed. Also, the question about But to be
the
clear, the
comments
mother
of the judge
was not
about
my client's pregnancy and all of that were really indicative, I think, of bias. And then his school decision has no support in the record. Yanked the children out of their school environment. Ricky, the oldest, for the 5th time transitioning, with no explanation as to why the children are enrolled.
If we remand, the children presumably are going to Sudbury schools now, as per the order. It hasn't been stayed, as far as I can tell.
Correct. He refused to stay it on grounds that don't make any
so
sense in the record.
do you? If we remand and ask for an explanation of that, presumably we would ask the judge to take an up-to-date look at that, because you can't unmove them now that they've moved to Sudbury, and moving them to Bolton, I think it is, at Bolton where she is
yes.
now, would be yet another move, which is not to say it's not the appropriate thing. I have no idea. I'm just an appellate judge here. But mother still wants a remand on that, even though her objection was subsequent moves rather than substantively that Sudbury was worse than Bolton or whatever. Do you see what I mean? The kids have moved now.
Obviously, I think if a remand occurs, there'll be an analysis of what is in the children's best interest now. I think all of this dovetails back to the parenting plan, which goes to primary residence, which goes to school eligibility issues. So it'll all probably resolve itself if the underlying parenting plan changes to a plan where mother has primary custody like she's always had.
If it does.
Right. So I just think there was a tenor in this throughout the proceedings that was negative and biased towards my client about her being pregnant with another man's baby while married to another man and still getting divorced. There was dismissive comments about husband's alcohol use, and this occurs in Europe all the time, and we're not going to address it. And the judge just ignored all of that. He had a double standard with respect to ignoring the fact that father was dating a daycare provider of the children while chastising my client for having a steady partner.
We know the
Just to be clear, though, by adding in the alternating weekends, in point of fact, as a practicality, the mother did get more time that she could be with the children, right?
Well, I guess more non-working time.
Yeah.
And non-school time, yes. And I'm not disagreeing that that's the one beneficial aspect of the case, but the judge granted father every single thing he asked for and adopted his findings verbatim, despite all of this evidence that bears negatively on his parenting ability. So it asks you to remand.
Are there further questions? Thank you very much. Your time has expired. Very good argument. We will hear now from Ms. Coyles.
Good afternoon, Your Honors. Jennifer Coyles on behalf of the appellee, Kurt DESCHLER. I'm here to ask the Court to affirm the probate and family court judgment of McSweeney that there has been no error of law here, nor has there been any abuse of discretion. That there are 3 issues before the Court brought by Ms. MICHELON. The parenting schedule, which Your Honor just discussed. That it was clear from the trial of this matter that both parties felt that the back and forth at that time period was not in the child's best interest, that they wanted a more consistent parenting schedule, and they both agreed that mother should, or both of their proposed judgments, that mother should get a full weekend, and we were in agreement. And I would suggest to the Court that that's exactly what Judge McSweeney did here. I want to remind the Court that originally this case had been pending since 2000.
Well, maybe he got to a reasonable place, but certainly his findings and rationale don't show a particular amount of elbow grease on his part.
For the parenting schedule, he did adopt a significant portion, if not the whole portion, of our proposed judgment. But he did make changes, which clearly show...
He just crossed out some paragraphs. He didn't change a word of any of the paragraphs he copied, right?
He did change the word to dividing up the marital home, which is not before the Court, but he did make those changes on the marital home, that mother was not going to be fully responsible on the formal marital home, although she vacated. And this goes back to the decision on the change in the school system.
Look, it's hard to say as a colloquial matter that the judge drafted this. He really just edited something drafted by the father, well, maybe by you or someone in your firm.
I will say that there is case law right on point under Cormier and its progeny that there is support as long as there's no abuse of discretion.
Well, I obviously you can use, he could, right? I mean, judges ask for proposed findings and they sometimes adopt them.
Correct.
These don't seem to address some of the difficult facts. They don't address the DUI. They don't address the ATV incident. They conclusorially say that maybe this is okay, that the various bruises and so on that Mother talked about were just from routine the bumps and bruises of childhood or whatever, although I'm not sure if there's sufficient evidence one way or another on that question in this record. They say nothing about the choice of Sudbury School at all. I mean, do you agree that that at least has to be remanded? There's no explanation at all. He kept saying at trial, I follow the pillow rule, I follow the pillow rule. Then he divides it 50-50 and doesn't explain why Sudbury instead of Bolton. Not that he couldn't do it, but why?
If I can answer that briefly.
Sure.
So he follows the pillow rule. He decided to do a 7-7, which was definitely in his discretion. It was beneficial for the mother. It was beneficial for the children.
How did he pick Sudbury?
He chose the Sudbury school system. Father had been historically living in Sudbury throughout this.
Historically?
Historically.
Following the separation.
Following the
They
separation.
had lived in a third town, right?
No. So if you follow the facts, Father left the marital home in in Hudson.
In Hudson, that's where they lived.
Because it was the determination of the mother that she wanted to retain the home. She decided at the very last minute, while this case was
Okay, but we're talking
during
about
the trial.
But the kids were in Bolton, and he switched them to Sudbury.
Not when this trial started.
At the end, when he issued his order. The children were already at school in Bolton. I'm not saying they couldn't be switched. I have no idea. I don't know anything about this. But the judge certainly doesn't explain why.
That is accurate. But I will go on to the joint legal custody aspect, and I think it plays into that. The one thing that the parents couldn't determine, and there is evidence, there is that's why there were exhibits, all those things getting to the benefit of which school these children should attend, because it was Father's position that it should be a shared, he was virtually a shared custodial situation before, that the one thing that was problematic and which Mother asked for in her proposed judgment was that she make the educational decisions. She didn't really want to make the educational decisions. She wanted the kids to go to school where she lived, which has always been her insistence throughout this. What's
wrong with that? Parents who fight in divorces always want the kid to go. I mean, unless there's some obvious reason, pre-existing school, that's a better school system, whatever. We frequently see the mom, neither of them lives in the marital home anymore. They've chosen two different cities. Yep. Maybe that was wrong of both of them or one of them, who knows. And they both want the kid, but there's nothing wrong with it. The judge just has to explain why it's in the best interest for the kids to go to one instead of the other.
So I think the judge implicitly did that in his rationale, that he stated that Mother would often, with her now husband, would interfere when the father was at school or at events and extracurriculars.
So the point was to make sure it was nearer to what I don't see what difference it makes what town.
So Hudson the children had historically gone back and forth from Hudson to Sudbury. And that was the comfort level of the kids. They were enrolled in activities already in the Sudbury school system and part of the Sudbury process, and they had that already. Bolton was something brand new that happened in the middle of this trial.
And yet, that's where the children were enrolled in school, because
Correct.
At the time, she was the primary custodial parent under the temporary orders, and they had been enrolled. I mean, like I said, maybe this isn't worth belaboring. You've already said he doesn't explain it. You say it's implicit, this and that. But there's no explanation at all. I'm not saying there couldn't be. Maybe Sudbury is the magical school system. Or maybe being near Dad is better because of commuting times. Or maybe, I have no idea. But he's not supposed to be punishing Mother for moving a little further away. It's best interest of the child.
And I agree with that. And I would suggest to the court that the best interest of the child was to remain in the Sudbury.
All right, but again, we don't take these arguments de novo here.
I understand.
Right? So I'd like you to show me where in the judge's findings or rationale the judge finds that it is in the best interest of the children to put them into a new school system, and why?
I don't think he specifically
Right.
says.
I've read it very carefully.
Okay.
And that was the judge's job.
But I think he can also do it, and with all due respect.
But he needs to do it.
But I think it also comes through in the rationale. If you look at page 7 of the rationale, that father stayed close to the original home of the parents, that he moved to Sudbury, he had been there for an extended period of time, that he was responsible.
Were there no houses available in Hudson?
I'm sorry?
Were there no houses available in Hudson so the children could stay in the school they were in?
How this trial started was Hudson was a very inferior school district to Sudbury.
Well, that's not how this case started.
No, but how the trial started. No, that's true. How the trial started was when we first started this trial. Keep in mind, when we first started, we essentially tried this case twice. It had started, then we had to redo it again. When we tried this the second time, that it was, when we started the trial, there was the difference between Sudbury and Hudson. There was a vast difference in the school systems at that time, and that was part of the exhibits that were put forth. Then all of a sudden, in the middle of trial, mother then moves. Doesn't tell dad where she's going, doesn't say anything about red.
She has to tell dad where she's going?
I would think so if they're both kind of parents.
Well, I assume she told when she had a change of address.
I would think that she would do it beforehand. They both own the marital home. They needed to decide what was going to happen with that, and there was none of that.
Did he discuss Sudbury with her before moving there?
He couldn't live anymore in the marital home.
I understand, but Hudson has more than one house in it.
It does, but he chose to purchase a home. So I think there's a difference, though.
But there are no findings
But
to any of this. There are no findings to any of this. I mean, without findings, I understand it's your view of the facts and what findings the facts could support, but we don't have judicial findings of that.
If I heard you, what you're saying is that implicit in the change was that he was trying to make it harder for the mother's partner to come over to Sudbury, that it would be more of a burden to do that.
That is not what I'm saying.
Okay.
What I'm saying is that there was a historical precedent set forth that the children were entrenched in the Sudbury area, that the father had been living there for several years. There were extracurricular activities there.
Can I ask you a hard question?
Sure.
Is the mother's pregnancy while in an adulterous relationship relevant?
No.
Not at all.
I do not believe it's relevant. It wasn't relevant to the parenting schedule here. I think.
Then why did you include it in your proposed findings of fact?
Because it had to be clear that the child born of this marriage was not my client's. There is a presumption that a child born of a marriage would be my client's, and we didn't want any presumption of that, and that's why we included it. It had to be very specific, and it had to be a finding. I would suggest to the court that's the only reason why we did it. It had nothing to do with it.
So you were concerned that even with the divorce finalized, because the child would be born during the Nisi period, that the child would be a child of the marriage?
That's the law.
That's the law.
That's the law. That was the only reason why we put it in there. It didn't have anything to do with whether she was pregnant or not pregnant or who she was pregnant with. It had nothing to do with that. It's just there had to be the law would have had it be his child, and we needed to address that. And that's the only reason why we put it in there.
So was the record undisputed that the father did take a while to come around to the older child being tested for educational issues like the ADHD?
I don't recall him taking a while, to be frank with you. He was not, at first blush, didn't want to jump right into that, but he definitely wanted to discuss it. He wanted to meet with the experts and determine that. And then once he did all of his background work, he was supportive of that, and that's what they did. I think the only, you can see, and I think Your Honor's brought forth, there was a 14-page stipulated partial judgment on this trial, that the parties were able to agree upon almost everything, and the one thing that they really couldn't agree upon was where the kids would go to school. And I think that was the basis of why Mother's here today, and she wants a second bite at the apple. And we would support that that is not appropriate, that father had historically, from the very get-go in 2014, the parties agreed to, they stipulated out to joint physical and legal custody. And they could not figure out a parenting schedule, which then another judge had to assist them with, and that was the schedule they had been going on
Where is
for almost
the
3 years.
stipulation of joint physical and...
It's the first temporary order.
It was not contested?
It was not, no, they stipulated out back in when with
Can
the
you
first
give
order
me
before
the record page?
I apologize, I don't have the record page myself, but it's the first stipulation for temporary orders, and then it then changed.
But that doesn't get into the partial stipulation for judgment.
No, but I'm sorry. I'm not,
wouldn't we need to see that? It's just a part, you stipulated for purposes of a temporary order.
Correct.
But that was not stipulated for purposes of the final judgment,
it was
it?
not. You're
Okay.
right. I'm sorry.
So, okay, just so we're clear.
Yeah, no, it was not. And that's what I'm saying is that the issues that essentially the biggest obstruct was, thank you, was where the kids would attend school. And that has always been. It was unclear whether Mother was moving. And again, things kind of flowed as this trial started. The trial started in July. It didn't end until December. No one was aware when it would start. When it was started, there would be this change of Mother's residence. I guess I want to add one more thing, just in the argument. It's axiomatic that the mother would be fine with this every other weekend, essentially, in her proposed judgment, and some limited time during the week. Whereas historically, again, for 3 years, they have been sharing in these custodial situations. There had not been any significant issues. There had been no change in this parenting schedule throughout this, other than one short period of time, and it had been going well. I think, too, you need to look at the trier of fact, who was Judge McSweeney. He got to observe both of these parties. He got to observe Mother's boyfriend at the time and kind of made the decision and used his discretion in that regard. Thank you. Any further questions?
No. Thank you very much. Another excellent argument, actually, by both of you. Thank you very much. An unfortunate case, but we see many, I'm afraid. Our final case for the morning.